The Washington State Court of Appeals Division 1 is now in session. Commissioner Masako Kanasawa presiding.
Good morning, Council. We are here for in the dependency of ACZ. Counsel for the mother, are you ready to proceed?
Yes, Your Honor.
Any time for rebuttal?
3 minutes, please.
Go ahead.
Good morning, Your Honor. I represent Ms. Zejas, and we've raised several issues here. Unless the court directs me otherwise, I'm going to focus on the due process challenge and the requirement of appointment of standby counsel when a parent chooses to proceed pro se. In Washington, parents have a right to counsel. They may knowingly waive that right to counsel and proceed pro se. The question here is whether due process requires standby counsel be appointed when a parent chooses self-representation. It's important to note standby counsel serves two functions. They are available to give a parent technical information and assistance, or parent or pro se litigant. It's to make the administration of justice a little more smooth, to protect the adversarial function. They don't direct the defense in that instance, but they play a very profound role in providing technical information. A second role of standby counsel is to be there when a parent decides that they cannot continue to self-represent, whether they may be, their status may be revoked for being obstructionist, or whether they choose to voluntarily absent themselves. That's an important role because it maintains the sense of process, fairness, and structure in our adversarial system.
Okay, can I ask you a question? So you do not dispute that the mother unequivocally, knowingly, intelligently, and voluntarily waived her right to counsel?
She waived her right to counsel, and under a standard waiver analysis, that would be acceptable. There is a question here, given the allegations that she had mental health issues. We urge that there should have been an Edwards type inquiry as part of the waiver inquiry.
I read the transcript and the trial court's findings, but it seems that the mother's erratic behavior has been raised as an issue, but there is no finding, but there doesn't seem to be evidence or of any mental illness or any mental health diagnosis, unlike the cases that you cited in a criminal context where the defendant has been committed to mental health hospital for psychiatric care with serious diagnosis. And so the competency is at the issue, whereas here there's no dispute that the mother was competent to proceed.
Well, there was a question and the court found that she was competent to proceed. That's the same in those criminal cases. They're competent to proceed. Whether they're competent to represent themselves is a completely unique question. And in all of those cases, in those criminal cases, there was a competency hearing, and they were competent to proceed as a litigant. They were not necessarily competent to represent themselves. And that is the Edwards inquiry. It's a very subtle distinction.
Mm-hmm. So you're making a categorical analysis as to any time a parent appears for, say, in dependency case, then the trial court is constitutionally required to appoint standby counsel.
We are arguing categorical, but I do understand that there has been a trend to apply the Matthews on a case-by-case basis. So either one of those. I do think, though, when you weigh the factors, they are so heavily weighed in favor of standby counsel that it should be categorical. At the very least, it should be required that there be a Matthews balancing in each and every case. In this case, it's not necessarily whether the mother was mentally ill or not. We don't have to challenge whether whether the waiver was constitutionally acceptable. In our Matthews analysis, we assume yes, it was, but there still needed to be standby counsel for the under the factors. Due process requires it.
But
Go ahead.
this is a situation where both Judge Messett and Judge Ramsayer assessed and reassessed, both of them, the mother's competency and pro se status multiple times, and then concluded that she is smart and she could proceed as pro se. So and the mother insisted that despite suggestions by the trial court that she wants to be on her own. So in that context, how what's the value of providing technical assistance to the mother in terms of your concern about decisional accuracy?
Well, I think the case speaks for itself. There was an empty defense table for much of this. The state got to waltz its evidence in there while the mom wasn't even present because she had decided that this was a criminal proceeding, that she would be in a criminal venture. There were lots of theories. And that is the problem here, is that it's not just the mom's interests at issue, it's the child's interest. We have the Supreme Court of the United States saying truth and fairness is best discovered by powerful statements on both sides. Our system of justice is based on the premise that the truth is best discovered through the adversarial system. That broke down here. It's very obvious. And if I can take a minute of my rebuttal time to finish this.
Sure.
The empty defense table. And so, yes, we can look at the technical assistance, but what's being forgot here is that pro se litigants can be obstructionists. They can voluntarily absent themselves, and then there's an empty defense table. Justice is not served for that child. Justice is not served. It's an incredible appearance of fairness problem, but it's the accuracy, the decisional accuracy is a problem when you have an empty defense table. And particularly,
do you acknowledge, though, that a competent civil litigant has a fundamental right to use her own intelligence and personal judgment and proceed as pro se?
I believe she can, but I also believe there's due process concerns here for the child as well. And also, even in the criminal context, they can proceed pro se, but there's absolute case law that says a standby counsel can be appointed even when they choose pro se to protect against the empty defense table.
Thank you.
I'll save the rest of my time for rebuttal. Thank you.
Miss Dusty? Sorry, Miss Taylor. Sorry.
Good morning, Your Honor. I'm Kelly Taylor. I'm Assistant Attorney General on behalf of the Department of Children, Youth, and Families. And the department, agrees, of course, that there are strong constitutionally protected liberty interests associated with dependency hearings. But those rights associated with dependency hearings may be waived. And in a civil case, the right to be heard, including the right to be present, may be waived. And this is not a new concept. We already have the LR case in Washington explaining that the parent's right to be heard is not self-executing, and he or she must take reasonable and timely steps to exercise that right. And that's a quote from the LR case. And we also have the AG case, which is a case from this division, which held that the parent's due process rights were not violated in a termination of parental rights default hearing when the mother had notice of the hearing and chose not to appear. So in a civil proceeding, such as a dependency proceeding, going forward with the hearing with an empty defense table has a special name, and that's called a default hearing. So perhaps nothing more clearly illustrates the distinction between a criminal trial and a dependency fact-finding hearing than this concept of a default order. Default orders don't exist in the criminal context. The court doesn't enter a conviction in the sentence for a defendant when the defendant does not appear. And this shows why the criminal cases relied upon by the mother are not applicable in the civil dependency context. So now here,
I have a question. Although, well, I ask you, is it a good idea though to appoint counsel regardless of to a parent in a dependency or termination case, regardless of the parent's wish to proceed pro se?
There was this valid waiver of the right to proceed with appointed counsel, and on this case, it would not have been appropriate then to, unless the parental interference was so bad that it was, you know, that the trial was breaking down, you know, in which case I suppose standby counsel would have been appropriate if it had to happen. But this case never reached that point. There was never the point where the mother's behaviors were so contemptuous or interfering with the trial process that the court felt that standby counsel had to be appointed for that reason. Instead, what happened was the mother voluntarily absented herself from the proceeding. So that's not a default, but there are some similarities with that decision that's being made at that point, because there is a waiver. You can waive these rights, and this was the mother's waiver of a known right to be heard and right to be present. So the record supports that conclusion, because not only was the mother present there at the start of the trial, but she obviously knew she had the right to be there, but she also had been personally served 6 months prior to the hearing with the notice and summons. The notice and summons set forth her important legal rights. The notice and summons told her that she should attend the fact-finding hearing. And then on the first day after the trial, when the recess was taken after the mother said she doesn't want to participate, the attorney for the department actually emailed her and said, you know, the court would hope you choose to participate, and then if you do not choose to participate, the trial will still go forward in your absence. And then the mother's own words show her statements, and her statements show her understanding of her right to be present. She says things like, bye-bye now, signing off. She says things like, talk to yourself, I don't care, I'm out. And these are showing her voluntary decision being made to absent herself from the courtroom. Now, notably at that point in time, she does not request appointed counsel before she signs off from the hearing. And so she shouldn't be permitted now to raise for the first time this concept of standby counsel. There's no manifest error here affecting a constitutional right, and there's no error. There's no argument showing prejudice or showing what standby counsel would have done. Presumably, standby counsel would have stood there and watched the mother provide the arguments and the cross-examinations that she provided and the closing that she provided. Her defense was essentially that there was no shelter care hearing that took place, but the trial court admitted into evidence as an exhibit the shelter care order. And the trial court heard the testimony from the social worker who was at the shelter care hearing. So there's really no showing of error and no showing of prejudice. And this issue should not be raised for the first time.
What about can you address the mother's argument that, well, it's unfair to raise the mother's potential issue of mental health concerns while proceeding, allowing her to proceed pro se?
Well, those cases, the Edwards case, the cases the mother's attorneys relying on, there are cases of questionably competent parents who questionably aren't able to assist in defense, but the civil standard for competency is different. And there's no question here that this parent was competent, not only prior to the trial with Judge Messitt, but after the 5-day trial. This was a 5-day trial, so after 5 days of Judge Ramsayer interacting with the mother, or at least there may not have been interactions the second day, but there were these extensive interactions that this trial court had with the mother. And at the end of the trial court stated, quote, that the mother fully understands the nature and the consequences of the proceeding. So, you know, it wasn't just that she got the gist of it. She fully understood the dependency proceeding. And as the mother herself said, she's been dealing with dependency proceedings for the past 11 years. And that's actually borne out by the record here because, you know, there were the prior dependencies of her other children that dated back for 11 years. So there was no violation of due process here. This was a fundamentally fair proceeding. The trial court was really, I think, bending over backwards to try to proceed in a fair way and did everything possible really to cajole the mother into agreeing to participate in this fact-finding hearing. The applicable procedural safeguards were provided. There was an appropriate assessment of the parent's competency prior to the trial, and then it was raised again by the CASA in front of Judge Ramsayer, and at the conclusion of the 5 days of trial, Judge Ramsayer made it very clear that she felt that this was a fully competent parent. So we have a valid assessment of competency, and we also have a valid waiver of their right to counsel. So these two processes, the waiver of the right to counsel and the assessment of competency and the colloquies that took place, they combine to really provide the adequate minimal due process under the record that's presented here. So there's really no trial irregularity that requires application of the Matthews balancing test. The only trial irregularity was that the mother voluntarily chose to absent herself from the courtroom for periods of time, and that constituted a knowing waiver of her right to be present and her right to be heard at those times when she chose to absent herself.
I just see that the only time she was evaluated, psychological, the child's first dependency setting, the Dr. Conner evaluated her and decided that the mother's problem solving and decision making abilities are actually areas of her strengths, although her active drug use could adversely affect that that skill set. Is there anything in the record that indicating that the mother has some mental health illness? I don't see any medical testimony or other than concerns.
The court cited to the portions of the record that I'm also familiar with. I mean, it is often the case in dependency proceedings that a drug addiction issue such as this one that was the long use issue for this mother. I mean, it's quite common that there is some sort of co-occurring mental health. I can't say for sure that this mother had no mental health issues, but the portions of the record that this court has cited to are the ones that I'm familiar with, that this was primarily a case of drug addiction. But in terms of competency, she was clearly fully competent. And a competent person is able to execute a valid waiver of the right to counsel, and they're also able to execute a waiver of the right to be present. And for those reasons, we'd ask the court to affirm the order and to find that either not to take it up because there's no manifest error showing here, or if the court does decide to look at it, to affirm the order of dependency and dispositional order.
Thank you. And now that respondent took additional time, I'll give you 3 minutes.
Thank you, Your Honor. I just want to start with that question of whether there was a mental competency or a mental health issue being alleged. I think that the record was somewhat misrepresented by opposing counsel. The trial court, even in its findings, said that the mother's emotional volatility contributed to obstruct her ability to accurately assess and report the facts. Both the CASA and the Attorney General asked that her competency be assessed several times. They put forward that her defense was based on delusions, and the mother's acting out clearly during the trial. The court has indicated it was a factor, but the Assistant Attorney General, the first sentences out of his mouth during closing was, "Look at how she acted during this trial. Can you imagine being a 6-year-old in her care?" That is using her self-representation against her as substantive evidence of unfitness.
But just because the mother shows some inappropriate behavior, pointing finger at the parties or just saying that she's going to sue everybody, doesn't mean that she has she's incompetent to proceed as pro se. I mean, the competency standard, even when you have mental illness like psychiatric illness, still there are instances where in a criminal case too, a party has been found competent regardless of the mental health issue.
Absolutely. And that's the thing that I think that everyone's sort of missing here in Edwards. You have to go back to the United States Supreme Court in Edwards. In Edwards, he was found competent as a party litigant. He was, and he waived his rights. Absolutely. But the court said, when you have these other issues, you have to go beyond. There has to be another factor in assessing whether he's competent to proceed pro se. That's different than competent as a party litigant. And I think that's what's being, I'm sorry.
But Edward was, had been found incompetent several times and had been evaluated and had received treatment, psychiatric treatment multiple times, even though he was eventually found competent. So isn't that different from the situation here, where the mother has never been found incompetent? I'm going to give you the time.
No, not at all. Not at all different. They're both competent, and if you're competent to be tried in a criminal proceeding, and the mother's competent to be a party litigant, they are both competent. But if you go back and look at what the state was alleging, that the mom was saying that she didn't even have a shelter care hearing and that was completely delusional and disconnected from facts, there's an issue here. And the court did not recognize its authority, its discretion to end her self-representation. And that's another fact. And the Assistant Attorney General led the court down an analysis that led it away from that discretionary decision and that discretionary power. And so that is another problem here, that the courts do not understand this. We absolutely need a published opinion that talks about what the courts in dependency proceedings can do with pro se parents. We need that.
Okay, thank you. This concludes today's hearing.
Thank you.